Okay. So you know how we always ask for like really out there hypotheticals, right?
Yeah, yeah.
You guys have really outdone yourselves this time.
Oh boy.
This one is straight out of a like biotech nightmare movie.
Oh, okay.
Buckle up, everyone, because today we are diving into the legal quagmire of what happens
Deep breath, everyone.
if someone unknowingly has their DNA modified by an injection,
Okay.
and then that altered DNA is like later patented
Oh, wow.
without them ever even knowing.
Yeah, that's a pretty big one.
It is a big one. So let's break it down.
All right.
You've got this person going about their life,
Right.
and they get an injection.
Just a regular injection, right?
Right, exactly. Could be anything.
Like a flu shot or a vaccine.
Exactly. But what they don't know is this injection contains something.
Something extra.
Yeah, something that modifies their DNA.
Oh, wow.
And then later on, completely separate, they get a routine blood test.
Totally normal.
Right, just standard procedure.
Okay.
And during the analysis of that blood sample, the lab discovers this unique modified DNA sequence.
Okay.
And then they go and patent it.
What?
Yeah, without ever even informing the person whose DNA it is.
Wow, so many layers to unpack here.
So many layers.
Ah.
So our mission today
Our deep dive mission.
is to figure out what legal recourse this person would have.
Right, because like on the surface, this feels so wrong.
On every level, it feels wrong.
Morally, ethically, legally.
Right, so let's start with that first part, the initial DNA modification.
Okay.
I mean, just the idea that someone can inject you with something that changes your very genetic makeup.
Without you knowing.
Without your knowledge or consent, it's mind-blowing.
Absolutely. And it definitely raises some serious legal red flags.
So where would we even begin, legally speaking, with something like that?
Well, the most immediate legal concept that comes to mind is battery.
Battery, like,
Yeah.
assault and battery.
Yeah, but specifically in a medical context.
Oh, okay, so how does battery apply here?
So at its core, battery is basically any unconsented physical contact.
So any medical procedure done without consent could be considered battery.
Exactly. And that includes injections.
So in our scenario,
Yeah.
if this person was injected with something designed to modify their DNA,
And they didn't explicitly agree to that?
they didn't know what they were agreeing to.
Right. That could very likely be considered a case of battery.
So that's pretty straightforward.
In theory, yes.
But wouldn't it be hard to prove that they didn't consent?
Well, that's where things get a little trickier.
Of course.
You would need evidence, documentation.
Medical records or something.
Exactly. Something that shows that the DNA modification aspect was never actually disclosed to them.
But what if there's no, written record of what wasn't said?
Right. That's a good point. It can get complicated.
So how could you prove lack of consent then?
Well, sometimes you can look for inconsistencies in the explanation that they received.
Oh, so if the doctor said one thing but the paperwork said something else.
Exactly. Or if their explanation just doesn't match up with standard medical practices for informed consent.
Ah, I see. So you could potentially bring in expert testimony.
Exactly. Expert witnesses who can speak to what proper disclosure should look like in that situation.
And what about that landmark informed consent case?
You're thinking of Canterbury v. Spence.
Yeah, that's the one.
Oh, yeah, that's a big word. It's from 1972.
Yeah, something like that.
It really set a precedent for patients' right to understand
To really understand the risks.
the benefit alternatives.
All of it. Before agreeing to any medical treatment.
And that includes knowing what's being injected into your body, right?
Absolutely. Informed consent isn't just a signature on a form.
Right. It's about true understanding.
Exactly.
So this person was told they were getting a flu shot, but they were actually getting a DNA modifier,
That's a clear violation of informed consent.
even if they technically agreed to the injection.
Exactly, because they didn't consent to the DNA modification itself.
So that brings us to another legal avenue, right?
You're thinking of medical malpractice.
Yeah, because if a doctor knowingly withholds information about a treatment, especially crucial information like this.
It's a breach of their duty to the patient.
Absolutely. Healthcare providers have a legal and ethical obligation.
To disclose all significant risks
All of them.
associated with any treatment they recommend.
And that includes potential long-term effects we don't even know about yet.
Right, because who knows what kind of long-term health risks could come from an unapproved DNA modification.
That's a huge unknown, and one the patient should absolutely be informed of.
So if this person did decide to pursue legal action, either for battery or malpractice,
What kind of damages could they realistically seek?
Right. What would be the potential outcome for them?
Well, the potential damages could be substantial.
Oh, really?
Yeah, especially if they can prove actual physical harm.
Like directly resulting from the DNA modification.
Right, but even if there are no immediate physical symptoms.
Which there might not be right away.
Exactly. The emotional distress alone could be grounds for a significant award.
I mean, imagine finding out that someone had messed with your DNA without your consent.
That's a huge psychological blow.
It would be terrifying.
And then there's the issue of potential future health problems.
Right. We talked about that.
Those can be harder to prove definitively, though.
Especially if they don't emerge for years.
Exactly. It becomes a question of speculation.
Which can be a legal minefield.
It can be. So proving damages in a case like this would require a lot of expert testimony.
Medical experts, scientific experts.
Right. To connect the dots between the DNA modification and any specific harm.
So, okay, let's shift gears now
Okay.
and talk about that second part of our hypothetical.
The patenting.
Yeah. So this lab finds the modified DNA in the blood sample
Uh-huh.
and they decide to patent it.
Which is just wild.
It is wild. So before we get into the legalities of that,
Right.
just for our listeners who maybe aren't patent lawyers,
Which is most of us.
can we do like a super quick patent law 101?
Okay, sure. Patent Law 101 and 67. Let's go.
Okay, go.
So basically in the U.S., you can't patent something that occurs naturally.
Like you can't patent a tree.
Yeah. Exactly. A tree is a product of nature.
It's not an invention.
Right. But you can patent inventions.
Things that are new,
Novel,
useful,
and non-obvious.
meaning it can't just be a small tweak to something that already exists.
Right. It has to be a significant enough change to warrant patent protection.
Okay, so that's the basics.
Patent Law 101 in a nutshell.
Now, where does DNA fit into all of this?
Well, this is where it gets interesting.
Because DNA is natural, right?
It is naturally occurring.
But it can also be modified.
And that's where the legal line gets blurry.
So is modified DNA patentable or not?
So there was this landmark Supreme Court case in 2013.
Myriad.
Yep, Myriad. They ruled that naturally occurring DNA sequences cannot be patented.
Right, because they're products of nature.
Exactly. But they also said that synthetically created or significantly altered DNA sequences.
Like the one in our hypothetical.
Exactly. Those can be eligible for patent protection.
If they meet those other criteria we talked about.
Novel, non-obvious, useful.
So this lab could argue that because the DNA was modified,
Even though it was done without consent.
it's no longer naturally occurring.
And therefore, it's fair game for patent.
But wouldn't that open up a whole can of worms?
It would basically mean anyone could patent anyone's DNA,
As long as they could modify it somehow.
which is a terrifying thought.
It's a slippery slope.
It is. And it raises some huge ethical questions.
Like who really owns our DNA?
Right. And what are the implications of allowing someone to profit from someone else's genetic material?
Those are questions for another deep dive.
Maybe a whole series of deep dive.
Okay, but for now, let's focus on our hypothetical.
Okay.
So this lab, they think they've got a patentable DNA sequence.
Mm-hmm.
But there's a catch, right?
Yeah, a big catch.
There is a huge legal problem with their patent claim.
Okay. I'm intrigued. Lay it on me.
Inventorship.
Yes. Inventorship.
Explain it to the people.
Okay, so U.S. patent law.
The all-important U.S. patent law.
It's very clear that a patent can only be granted to the actual inventor
Or inventors.
of the claimed invention.
So you have to prove that you actually invented the thing you're trying to patent.
Right, and that's where the lab's argument falls apart.
Because they didn't create the modified DNA sequence.
They just discovered it in the blood sample.
It was already there.
So they're not the inventors.
In fact, the true inventor in this twisted scenario,
Is whoever injected that DNA modifying substance.
which is so bizarre.
It is. It's like the opposite of how it should be.
Right, the person whose DNA was modified is the victim.
And yet, legally speaking, they're the inventor.
This is a legal pretzel.
It is. And it highlights a key point about patent law.
Okay, tell me.
Patent law is designed to reward creation, not just discovery.
That makes sense.
You have to actually invent something new and useful to deserve a patent.
Not just stumble upon something that already exists.
Exactly. So the lab, in this case, they're trying to patent something they didn't create.
That didn't invent it.
And that's a huge problem for them, legally speaking.
So our hypothetical person could actually challenge the lab's patent.
They absolutely could, and they should.
On what grounds?
Lack of inventorship.
Which is a real legal thing.
It is. It's outlined in 35 U.S.C. Section 116.
So they could potentially get the patent invalidated?
Potentially, yes. But it wouldn't be easy.
Of course not. Nothing in law is ever easy.
Right. Challenging a patent is a complex and expensive process.
But it could be worth it in this case.
Absolutely. Especially if it prevents the lab from profiting off of someone else's DNA.
So what if, let's say, the person who did the injecting
A mad scientist in our story.
had actually patented the modification beforehand?
Oh, that's an interesting wrinkle.
It is. Would that change anything?
It would change the legal landscape for sure.
Okay, how so?
Well, if the injector already had a patent on that specific DNA modification,
Then the lab's patent would be invalid.
most likely yes, because it wouldn't be novel anymore.
Someone else already invented it.
Exactly. But here's the thing.
Okay.
Even if the injector holds the patent,
It does not make the situation any better for the person whose DNA was modified,
right?
because their fundamental rights were still violated.
Exactly. The initial wrong, the unconsented modification,
That's still a huge problem.
regardless of who owns the patent.
So this whole scenario really makes you think about DNA ownership.
It does. It's a fundamental question.
Do we own our own DNA?
It feels like we should.
Right. It's literally part of our bodies.
It's our genetic blueprint.
So intuitively, you'd think we have some kind of property right over it.
Right. But legally speaking,
This is where things get murky.
very murky.
So legally, do we own our own DNA or not?
Unfortunately, there's a legal precedent that makes this very complicated.
Oh no, what case is this?
It's called Moore v. Regents of the University of California.
Oh yeah, I've heard of that one.
It's from 1990, and it's a big one.
Okay, refresh my memory.
So in this case, the California Supreme Court ruled that a patient did not have property rights
In his own cells.
right after they were removed from his body.
Even though those cells were later used to create a valuable patented cell line.
Yep, that's the key point. The court basically said that extending property rights to excise biological materials.
Could hinder medical research.
Exactly. They were worried about the implications for scientific progress.
So even though it feels like we should own our DNA,
This case suggests that once it's outside of our bodies,
like in a blood sample,
we lose those property rights.
which is kind of mind-blowing.
It is. It challenges our very notion of bodily autonomy.
So even in our hypothetical situation where the DNA modification was forced
It's likely that the person wouldn't have a strong legal claim to ownership.
over that modified DNA once it's in that blood sample,
That's the tricky part. The precedent set by Moore makes it very difficult to claim ownership of your biological material.
once it's been removed from your body.
Right. And that makes it harder to challenge the lab's patent based solely on ownership claims.
It does. So this whole scenario also feels like a massive invasion of privacy.
Oh, absolutely.
You go in for a routine blood test.
Something that's supposed to help you.
Right, you're trusting your doctor, the lab,
To use your blood for legitimate medical purposes.
and then suddenly you find out that they've analyzed your DNA
Patented it.
without your knowledge or consent.
It's a huge breach of trust.
It feels like there should be some kind of legal protection against that.
There should be. And in some cases, there is.
Okay, tell me more.
So in the U.S., we have HIPAA.
Hi, the Health Insurance Portability and Accountability Act.
That's the one.
That's the big privacy law for health information, right?
It is. It sets limits on how healthcare providers and others can use and disclose protected health information.
So that includes things like medical records,
Genetic information.
blood test results.
All of that is protected under HIPAA.
So wouldn't that apply to our hypothetical situation?
It might, but there's a catch.
Oh, there's always a catch.
Right. So HIPAA often allows for the use of de-identified samples for research purposes.
De-identified, meaning they've removed any personal information.
Exactly. They strip away your name, your social security number.
Anything they could directly link the sample back to you.
Right. So the big question in our case is whether the lab de-identified the blood sample.
Before they analyze the DNA and file the patent,
If they did de-identify it,
they might be in the clear.
potentially yes, because they'd argue that they weren't using the person's protected health information.
But if they didn't de-identify,
And they were able to link that specific DNA sequence back to the individual.
that could be a HIPAA violation.
It could be. And that would give the person a strong legal argument.
So that's if they violate HIPAA.
Right.
But what if they technically didn't violate HIPAA?
Are there other legal avenues?
Right. Could there still be a breach of some kind of duty?
Absolutely, even if HIPAA doesn't apply.
I'm listening.
There's this concept called fiduciary duty.
Fiduciary duty, that's a big one.
It is. It basically means that someone has a legal obligation to act in your best interest.
So like a doctor has a fiduciary duty to their patient.
Exactly. Or a lawyer to their client.
So how does fiduciary duty apply to our hypothetical?
Well, if the doctor who ordered the blood tests or the lab analyzing the sample,
They had this fiduciary duty to the person,
right, to act in their best interest.
then using that blood sample for their own profit.
like by patenting the DNA without consent.
That could be seen as a breach of fiduciary duty
Exactly. And it would be especially egregious.
if there was an expectation of confidentiality.
Right, like if the person was told the blood test was for routine medical purposes.
And they never consented to it being used for research or patenting.
That would definitely strengthen their case.
So what kind of damages could they seek for a breach of privacy or fiduciary duty?
Well, they could definitely seek compensation for emotional distress.
Which, as we talked about, could be significant in a case like this.
Right, and in some cases, they might even be able to get punitive damages.
Punitive meaning designed to punish the wrongdoer.
Exactly. It's not just about compensating the victim.
It's about deterring this kind of behavior in the future.
Right, sending a message that this kind of exploitation won't be tolerated.
So let's put all this together now.
Okay.
Let's say this person, they're living their life.
And then, bam, they find out about the DNA modification.
And the patent.
What can they do?
What are their options?
Well, first things first, they need a lawyer.
A good lawyer.
A lawyer who specializes in medical law, patent law, privacy law.
The trifecta.
Exactly, because this case touches on all of those areas.
Okay, so they've got their legal team assembled.
Oh, what's next?
What are their options for legal recourse?
Okay, so as we discussed earlier, they could potentially sue the person who gave them the injection.
For battery.
For medical malpractice.
Maybe even intentional infliction of emotional distress.
Right. It all depends on the specific circumstances.
And the evidence they can gather.
Exactly. But there's a time limit.
Right. The statute of limitations.
Exactly. They can't wait too long to file a lawsuit.
But there's that discovery rule thing, right?
Yes. The discovery rule could be a game changer here.
Explain it to the folks at home.
So the discovery rule basically says that the clock starts ticking
On the statute of limitation.
when the person discovers the wrongdoing.
Not necessarily when the wrongdoing occurred. So in our case, if the person didn't find out about the DNA modification until years later.
The statute of limitations wouldn't necessarily prevent them from filing a lawsuit.
Which is a good thing.
It is. It gives them a chance to seek justice, even if the initial act happened long ago.
So that's for suing the injector.
Right.
What about challenging the patent itself?
That's a whole other legal battle.
How would they go about doing that?
So they would have to go through the U.S. Patent and Trademark Office, or USPTO.
USPTO, the patent people?
Exactly. And there are a couple of different options.
Like what?
They could file a petition for post-grant review.
Post-grant meaning after the patent has been granted.
Exactly. Or they could file for inter partes review.
Which is another type of patent challenge.
It is.
Ah.
Both of these options allow someone to argue that a patent is invalid.
On what grounds?
In our case, the main argument would be lack of inventorship.
Right, because the lab didn't actually invent the modified DNA sequence.
They just found it.
And if they could prove that,
the patent could be invalidated.
which would be a huge victory.
It would be. But it's important to understand that invalidating the patent...
It doesn't change the fact that the person's DNA was modified.
Right, that's a separate issue.
So they'd still need to pursue legal action against the injector for that.
Absolutely. The patent challenge is about stopping the lab from profiting.
Not about undoing the initial harm.
Exactly.
So what about legal action against the lab itself?
After the patent has been granted.
Right. What are the options there?
Okay, so they could definitely sue for privacy violations.
Especially if the lab violated HIPAA.
By not de-identifying the sample.
Right. We talked about that.
They could also potentially sue for unjust enrichment.
Unjust enrichment meaning
that the lab profited unfairly from the person's DNA.
without their consent or compensation?
Exactly. And in a more extreme scenario,
Okay, lay it on me.
if they could prove that the lab knew the DNA was modified without consent,
And they intentionally concealed that fact.
while they were pursuing the patent.
That could be a case of fraud.
It could be, but proving that level of intent.
It's very hard.
It is. It would require a lot of evidence.
Emails, internal documents, whistleblowers.
It would be a tough case to make.
But not impossible.
Not impossible, but definitely challenging.
Okay, so we've covered a lot of legal ground here.
We have.
And it's clear that this hypothetical situation.
It's a real legal and ethical quagmire.
So if this were to happen in real life,
which hopefully it never does.
what are some of the biggest challenges someone would face trying to pursue legal action?
Well, one of the biggest hurdles would be proving everything.
Proving that they got the injection.
Proving that the injection modified their DNA. proving that the lab knew about the modification.
That's a lot of proving.
It is. And it could require extensive investigation.
Expert testimony.
Scientific evidence.
It would be a long, complicated process.
Absolutely. And very expensive.
So it's not something to be undertaken lightly.
No, definitely not. It would be a major legal battle.
So another thing we touched on earlier, what if the DNA modification happened in germline cells?
Meaning it could be passed down to future generations.
Right, that opens up a whole other can of worms.
It does. It raises questions about whether someone could patent a genetic trait.
And then control its inheritance.
Which is a terrifying thought.
It is. Thankfully, though,
Thanks, Lord.
courts are very unlikely to enforce patents on natural reproductive processes or natural inheritance.
Right, even if the underlying DNA sequence was initially patented.
Because of an artificial modification.
Exactly.
Right.
The courts are very hesitant to interfere with natural biological processes.
Which is a good thing.
It is. It would be a nightmare scenario if someone could control the inheritance of genetic traits.
So this whole conversation also raises broader ethical questions.
About genetic modification and human rights.
Right. Are there any international laws or ethical frameworks that address this kind of stuff?
There are, actually. There are several international agreements.
Like what?
Well, there's the UNESCO Universal Declaration on the Human Genome and Human Rights.
That's a mouthful.
It is, but it's a really important document.
What does it say?
Well, it basically emphasizes the importance of human dignity.
The protection of genetic information.
And informed consent for any interventions involving the human genome.
So any kind of genetic modification would have to meet those standards.
Exactly. And it explicitly condemns any unconsented genetic manipulation.
So that would apply to our hypothetical situation.
Absolutely.
Yeah.
It would be a clear violation of those principles.
But these international agreements...
They're not always legally binding.
Right. They're more like ethical guidelines.
Exactly. They set a moral standard.
But they don't always have the force of law.
Which is a problem.
It is.
Yeah.
Because it means that even if something is ethically wrong...
It might not be legally actionable.
Which is a frustrating gap.
It is. It highlights the limitations of international law.
Okay, so to wrap up this incredibly complex and unsettling deep dive...
Deep breath.
Let's try to summarize the potential outcomes for someone in this situation.
Right. What are their best options?
So realistically, what are their chances of getting justice?
Okay, so to reiterate, the most direct and likely successful legal path
Is to go after the person who did the injecting.
for battery or medical malpractice.
Because that's where the clearest violation occurred.
Exactly. They didn't have informed consent for the procedure.
And that's a strong legal argument.
It is. And they could potentially win a significant amount of damages.
To compensate for the harm they suffered.
Right. Both physical and emotional harm.
Now, challenging the patent,
That's a more uncertain path.
even though the lab's claim is weak.
Because they didn't actually invent the modified DNA.
It's still a complex and expensive process.
And even if they win.
It doesn't reverse the DNA modification.
Right. That's a separate issue.
So it's a victory with limitations?
It is. It's not a complete solution.
Now, what about the lab's liability?
Could they be held responsible for anything beyond the patent?
So if they knowingly exploited the situation,
If they knew the DNA was modified without consent,
and they patented it anyway,
that could open them up to additional legal claims.
like what?
Well, we talked about privacy violations, unjust enrichment,
Even fraud.
but proving their knowledge and intent.
That's the hard part,
It is. And the Moore case.
right? The one about the lack of property rights over biological material.
That case could limit their liability somewhat.
So it's a complex legal landscape.
It is, but the bottom line is,
The initial violation of consent.
that's the most direct and likely successful legal avenue.
Okay, so big takeaways for our listeners.
Takeaways time.
Informed consent is crucial.
Absolutely. You have the right to know what's being done to your body.
DNA patentee is complicated.
It's not a free-for-all.
And owning your own DNA,
It's not as straightforward as you might think,
especially once it leaves your body.
thanks to Moore v. Regents.
So, a lot to think about.
A lot to ponder
But this deep dive has hopefully shed some light.
on a very complex and unsettling topic,
It has, and it's also raised a whole bunch of new questions.
which is what we love to do here at the Deep Dive.
So to our listener who brought us this hypothetical,
Thank you
thank you for making us think.
for challenging our assumptions.
And for reminding us that the future of biotechnology,
It's not all sunshine and roses,
there are some serious ethical and legal issues to consider
and we need to be having these conversations now.
before it's too late.
Absolutely. The future's coming.
And we need to be prepared.
So keep those hypotheticals coming.
We love a good challenge.
And who knows, maybe your hypothetical will be our next deep dive.
Until next time, stay curious.
And stay informed.
Have you ever thought about, what makes us human? It's kind of a deep question, but lately there's been this buzz about tweaking our DNA.
Right.
And it really gets you thinking.
Mm-hmm.
Can someone actually own a piece of our biology just because they changed it? It's like something straight out of science fiction.
Yeah, it really is. And that's what we're diving into today, this whole idea of patenting modified human DNA.
It's pretty mind-blowing.
Yeah. With all the advancements in gene editing and all that, this question is becoming more and more relevant.
Definitely.
So we've got some seriously interesting stuff lined up for you today, including expert opinions on the legal side of things. We
Absolutely.
want to really break it down and help you understand what patenting modified human DNA actually means.
Without getting too bogged down in the technical stuff.
Right, exactly. We want to make sure it's clear and engaging. I think you'll find some pretty surprising things along the way.
Yeah, I think so too.
Yeah.
So basically the big question, the one that's probably on your mind too, is this. Can you actually patent changes to human DNA?
Right.
And if you can, what does that mean for us as individuals?
Exactly.
We've been looking at a bunch of different sources, articles and online discussions,
Mm-hmm.
and even an online post that asks this exact question.
Yeah, that's a good one.
And then there's the legal experts who have really delved into this.
Right. They've been thinking about this for years. And what's really interesting is that here in the U.S., there are already some legal boundaries in place.
Yeah, I was reading about that. There was a pretty landmark case, right? The Association for Molecular Pathology v. Myriad Genetics. I think it was back in 2013.
That's the one. That was a really pivotal moment in defining the limits of DNA patenting.
Okay, so what was the main takeaway from that case? What did it actually decide?
Well, the big thing that came out of Myriad was that you can't patent naturally occurring DNA.
Okay.
The court basically said that even if you isolate a gene from the body, it's still a product of nature.
Right.
So it doesn't qualify for patent protection.
That makes sense. You can't just own something that's already part of the natural world.
Exactly.
But I seem to remember that the ruling didn't completely shut down DNA patents.
Right, you are.
Where did it leave some wiggle room?
So while they said no to natural DNA patents, the court made it clear that synthetic DNA could potentially be patented.
Oh.
Things like complementary DNA or cDNA.
cDNA, yeah, I've heard of that.
So just to explain, cDNA is a DNA sequence created in the lab.
Okay,
It's made from messenger RNA, so mRNA.
gotcha.
And unlike the DNA in our cells, it doesn't have those non-coding regions, the introns.
Right.
So basically, it's artificially created.
So it's like scientists engineer a completely new sequence in the lab,
Mm-hmm.
and that could potentially be patented.
Exactly. And this also applies to modifications made to human DNA using things like CRISPR technology.
CRISPR, yeah, that's the big one these days.
If researchers create a new DNA sequence, or even just a specific change that doesn't naturally exist, and if that invention is useful and not something that's obvious, to someone in that field,
Like a breakthrough, not just a simple tweak.
right, then it could be patented.
So there's a chance we could see patents on, say, a specific sequence that's designed to fix a genetic disease.
Yeah, potentially.
Using CRISPR.
Using CRISPR, exactly. But, and this is super important to understand, having a patent on a modified sequence, or even the CRISPR technique itself, doesn't mean that someone owns a person if their DNA includes that modification.
That's a really crucial distinction.
Yeah, the patent is about the specific invention, the sequence or the method, not the person.
So if I were to get gene therapy using a patented sequence, the company with the patent doesn't suddenly own me or my cells.
Not at all.
That's good to know.
Patents give you economic rights. They mean the patent holder can stop others from making, using, or selling their invention without permission. It's about intellectual property, not owning a person.
Okay, that makes a lot more sense. But even with that line drawn, it still feels a little iffy,
Yeah, I get it.
Patenting changes to human DNA.
Yeah.
It brings up a lot of ethical questions.
Absolutely, it really does. This is where the legal stuff intersects with human rights, which is a whole other layer.
Right. So what kind of human rights principles are we talking about here?
Well, there are some big ones. The Universal Declaration of Human Rights, or the UDHR.
Okay.
It has Article 3, which says everyone has the right to life, liberty, and security of person.
Right.
And when you think about our biological makeup, bioethics principles, like those in UNESCO's Declaration on the Human Genome,
Mm-hmm.
they emphasize that the human genome is part of our shared heritage. It shouldn't be a source of profit in its most basic form.
Okay.
And they also say that people can't be reduced to their genetic code, and no one should own or control them because of it.
So essentially, you can't treat someone like property based on their genes, whether they've been modified or not.
That's the core idea.
Yeah.
But then you run into a tricky situation. Patent rights have practical implications, and those can bump up against human rights, especially the right to health. That's in Article 25 of the UDHR.
Okay. How does that conflict actually play out?
Let's say a company has a patent on a gene therapy,
Okay.
and this therapy is life-saving, really crucial. They get to decide how it's made, distributed, and priced.
Right.
If it's super expensive or if they choose to limit access.
The people who need it can't get it.
Exactly. And that could be seen as violating the right to health.
So the concern is that these patents could make it harder for people to access important medical treatments.
Precisely. You have this push and pull between the idea that patents encourage innovation, which could lead to more treatments down the line, but then there's the worry that those same patents could turn vital medical advancements into commodities.
Yeah, and make them inaccessible to people who need them most.
Exactly.
And this makes me wonder about future generations.
Yeah.
If a gene modification is heritable, passed down, and it's patented, what happens when someone with that modification has kids? Does the patent holder have a say in the genetic makeup of those children?
That's a really great question, and it gets into a really complex area of patent law.
Yeah, it's not a simple one.
You're basically asking how a patent holder's right to stop others from making their invention applies when DNA is passed down naturally.
Right, because when you talk about making something in patent law, you usually think of creating something in a lab.
Exactly.
Natural reproduction isn't really making in that sense.
You're right on the money there. In patent law, making usually refers to the deliberate act of creating the patented invention,
Okay,
like in a lab using a specific process.
but like with that modified DNA sequence.
Right. It's about artificial creation, not natural inheritance.
But if someone with a patented gene edit, that's heritable, has a child, neither the parent nor the child is making the patented DNA in a way that would infringe on the patent.
Exactly. The law separates artificial creation, which patents cover, from natural processes like inheritance. The myriad decision we talked about earlier that back this up too.
Right.
Natural DNA can't be patented. So a patent holder wouldn't normally have grounds to sue a parent or a child just because the child inherited modified DNA.
Right.
That's not the kind of making patent law is concerned with. They're more focused on preventing companies or labs from reproducing that modification for profit,
Okay,
not on individuals having children.
that makes sense.
Yeah.
But you mentioned earlier that it could get a bit messy.
Right.
So where do those complications pop up when we're talking about heritable modifications?
The complications come in when you think about someone else using that patented heritable DNA for commercial purposes.
Oh, okay.
Let's say the modification gives you a big advantage, like resistance to a disease,
Okay.
and then another company tries to develop a similar treatment or do research based on that genetic sequence. Even though it's already present in some people's DNA, the original patent holder might say, hold on, you're infringing on my patent. You're using my invention.
So even though those people inherited the modification naturally, using it for research or developing a new treatment could be a problem.
It could be.
That's pretty complicated.
Yeah, it is.
So could they demand licensing fees from researchers who are studying cells from people with the patented DNA?
Potentially, yeah.
Or could they block the development of new therapies based on what those researchers learn?
Those are exactly the kinds of questions that we don't have clear legal answers for yet.
It's all very gray.
It is, very much so. Proving direct patent infringement would probably require showing that the competitor is actually recreating the exact sequence or method,
Right.
not just observing it in someone's DNA. But the patent holder could still try to assert their rights in these situations.
And again, that brings us back to the ethics.
Yeah.
If these patents make it harder to benefit from heritable modified DNA, it could lead to some serious issues with fairness and equality.
You got it. The legal focus might be on the act of making something, but the real-world impact on access and how those benefits are shared could be huge.
This is really making my head spin.
I know, it's complex.
What about some real-life scenarios?
Yeah, let's get practical.
Let's say someone with patented modified DNA dies and wants to donate their organs.
Okay.
Or what about donating blood while they're still alive?
Right.
Does the patent come into play in those situations?
Those are excellent questions, and they really show how this could affect people's lives. So let's start with organ donation.
Okay.
If someone with patented DNA donates an organ that has that modification, the patent itself usually doesn't stop the donation.
Okay.
Donating an organ is generally seen as separate from commercial patent use, especially because it's an altruistic act.
Right. It's about saving lives.
Exactly. And there are laws that govern this, like the Uniform Anatomical Gift Act in the U.S.
Okay.
When you donate an organ, you're not making the patented DNA, you're transferring existing material.
So the hospital that receives the organ isn't suddenly breaking a patent just by accepting it.
That's generally how it's understood, but
Yep.
there is a hypothetical situation to consider.
Okay.
If the recipient or some other party uses the organ in a way that exploits the patented DNA for commercial gain, like if a company studies the organ to figure out how the modification works and then tries to copy it to sell,
Okay.
the original patent holder might try to say their patent is being infringed.
They could claim that the patented DNA is being used in a way that violates their rights.
Exactly.
But that seems really unlikely, especially when we're talking about organ donation.
Yeah, it's highly improbable. It's unlikely a patent holder would try to interfere with an organ donation. Public health concerns, ethical obligations, and laws around organ donation would almost certainly outweigh patent claims.
Right.
The main purpose of organ donation is to help people, not to make money.
Yeah, of course.
There's also something called the exhaustion doctrine, which basically suggests that once a patented item is legally transferred, the patent holder's control over it is limited.
Okay.
But how this would apply in the case of organ donation, that hasn't really been tested.
That's uncharted territory.
It is.
What about blood donation? It's a bit different because the person's still alive.
Yeah, blood donation is similar to organ donation in some ways, but there are some differences.
Okay.
So if someone with modified DNA donates blood, the act of donating isn't considered making the patented DNA. It's a natural part of their body.
Right.
And organizations collecting blood for transfusions, they're not replicating the DNA for profit.
It's a nonprofit medical use.
Right.
But what if the blood is used for something other than a transfusion, like research?
That's where things could get a little tricky again.
Okay.
If donated blood with patented DNA is used for something beyond a standard transfusion, like if a lab extracts the DNA to study it or to develop a commercial therapy,
Right.
the patent holder could potentially argue that their rights to use or sell their invention are being infringed.
So again, it depends on whether there's a commercial intention.
Yeah. Nonprofit research or typical medical use like a transfusion, those are less likely to cause patent issues.
Wow.
But there's also a practical question here.
Yeah.
How would a patent holder even keep track of their patented DNA in the whole blood donation system?
Right. It's not like they can follow every unit of blood.
Exactly. Blood donations are usually anonymous and they're often pooled together. So it would be incredibly hard, if not impossible, for a patent holder to track their specific DNA. Plus, the amount of modified DNA in a single donation is usually pretty small.
Right.
So unless someone is extracting large amounts of that DNA for commercial use, it probably wouldn't make sense for them to go after infringement claims.
It wouldn't be worth it.
Not really.
So basically, for both organ and blood donation, even though there might be some theoretical patent concerns, the reality is that saving lives and the well-being of the recipient are the top priorities.
Absolutely. If someone tried to restrict organ or blood use based on a patent, they'd likely face a ton of opposition from both an ethical and a public policy standpoint.
Right. It would basically limit access to vital resources. And that goes against the right to health.
Precisely.
You know, this whole conversation reminds me of something I saw online recently.
Oh, yeah?
Someone with the username @Classica posted a question. They asked, if scientists found a way to modify human DNA to eliminate hereditary disease, should the new DNA be patentable?
That's a good one.
Yeah, and they went on. If yes, how does that work with human rights? If no, why not?
That's a great question, and it really gets at the heart of what we've been talking about.
I know, right? There were a few responses to the post. Some people were worried about corporations basically owning life.
Right.
And others said that patents are necessary to encourage innovation.
It's a classic tension.
It is. But that post from October 16th, 2024, it really sums up the whole dilemma. The potential benefits of patents versus the fundamental human rights concerns.
It really does. And our conversation has laid out a way to think about that question.
Definitely.
We've established that, legally speaking, in the U.S., synthetic modifications to DNA can be patented.
Right, like we talked about with the Myriad decision.
Exactly. And that gives the patent holder economic control. But we've also stressed that this doesn't mean they own the person with that DNA.
Right.
We've also highlighted the ethical side of things, especially when it comes to fair access to these potentially life-changing modifications.
Yeah, that's a big one.
There's this constant balancing act between encouraging innovation and making sure the benefits of those innovations are available to everyone.
Right. And then there's the whole issue of heritable modifications and using biological materials like organs and blood that contain patented DNA. Yeah, those areas are still evolving, legally speaking. Lots of unanswered questions.
There's the gray areas.
So if we were to give at Classica a quick answer based on what we've talked about today, it would be something like, yes, synthetic DNA modifications can be patented, but that brings up major human rights concerns about access. And thankfully, donating organs or blood with patented DNA usually isn't a patent issue.
That's a great summary. Really captures the key points.
So for you, the listener, let's recap the main things to remember.
Number 1, in the U.S., modified human DNA can be patented, but only if it's synthetic and meets the criteria for patentability.
Which are novelty, usefulness, and non-obviousness.
That's right.
Number 2, those patents give the patent holder economic rights, control over how their invention is used commercially. They don't own the person who has that DNA.
Exactly.
Number 3, the overlap between patent law and human rights brings up a ton of ethical questions.
Big ones.
Especially about making sure everyone has equal access to potentially life-saving genetic modifications.
Right. And there's always that tension between pushing for innovation and ensuring everyone benefits from it.
And finally, the legal rules around heritable modifications and the use of things like organs and blood that contain patented DNA are still being worked out.
Lots of complex questions still to be answered.
That's for sure.
And this leads to another question, something for you to think about.
Okay.
As gene editing gets more and more advanced, how do our values as a society and our legal systems need to adapt to ensure that science keeps progressing, but we also protect fundamental human rights?
Right.
Especially as these modifications become more complex, it's something to really consider. How will all of this affect society in the long run? How do technology, law, and human rights all intersect? It's a fascinating and crucial question.
It is. It's something we'll all need to keep thinking about as these technologies evolve.
Absolutely.